What rights do I have if I'm fired on the spot? Imagine this. You're halfway through your shift, doing your usual work. Suddenly, your manager calls you into the office and says, "You're done here. Pack up and leave, effective immediately." No notice, no paperwork, no explanation. Just like that, you've been fired on the spot. It feels shocking, confusing, and unfair. You might ask yourself, is this even legal? Do I have any rights if I'm fired immediately without warning? Many workers believe employers must give 2 weeks' notice or follow a 3 strikes policy. But under U.S. law, the reality is different. In this video, we'll explain what at-will employment really means, when immediate termination is legal, the situations where it crosses the line into unlawful firing, and what workers can do next. By the end, you'll know exactly what protections exist if you're fired on the spot. At-will employment, the default rule. In most of the United States, jobs are governed by at-will employment. That means employers can terminate employees at any time, with or without notice, and without giving a reason. Likewise, employees can quit at any time. So if you're fired on the spot, in many cases, that action is perfectly legal under at-will employment. Employers don't have to follow progressive discipline unless they promise to in a contract or handbook. Example: a cashier is let go mid-shift after making repeated mistakes. No written warnings were given. That's lawful under at-will employment, unless other factors like discrimination are involved. The myth of required notice. Workers often believe employers must give 2 weeks' notice before firing. That's not the law. The 2 weeks standard is a professional courtesy, not a legal requirement. Employers can terminate immediately. But if you have a contract or collective bargaining agreement, things change. Contracts often require just cause for termination and may mandate notice or progressive discipline. In unionized workplaces, firing on the spot is usually challenged through the grievance process. Example: an airline worker under a union contract is terminated on the spot. The union steps in, demanding evidence of just cause. The employer cannot rely on at-will rules. Protections against discrimination. Even at-will employment has limits. Employers cannot fire workers for discriminatory reasons. Protections include Title VII. Bars termination based on race, color, religion, sex, or national origin. ADA. Protects workers with disabilities. ADEA. Protects workers age 40 and older. Pregnancy Discrimination Act protects against firing based on pregnancy. If you're fired on the spot and suspect the real reason relates to a protected category, the termination may be unlawful. Example: a 45-year-old worker is fired immediately, while younger co-workers with worse records remain. That may suggest age discrimination under the ADEA protections against retaliation. Retaliation is another major exception. Employers cannot legally fire you on the spot for exercising your rights, such as reporting safety hazards under OSHA, filing wage complaints under the FLSA, requesting medical leave under the FMLA, participating in union activity under the NLRA, filing discrimination complaints with the EEOC. Example: a warehouse worker reports unsafe equipment to OSHA. A week later, he's fired on the spot. That looks like retaliation, which is unlawful. Public policy exceptions. Courts in many states recognize public policy exceptions to at-will employment. Employers cannot fire you for reasons that violate fundamental public policies, such as refusing to break the law, serving on jury duty, filing for workers' compensation after an injury, reporting illegal activity, whistleblowing. Example: a driver refuses to falsify records of hours worked. He's fired on the spot. That's likely unlawful under public policy protections. Contracts and employee handbooks. Employment contracts and company policies can override at-will rules. If your contract guarantees notice or progressive discipline, firing on the spot may breach that agreement. Similarly, if the handbook promises steps like verbal and written warnings, courts sometimes treat that as enforceable. Example: a handbook states, employees will not be terminated without at least one written warning. An employee is fired on the spot. That broken promise may support a wrongful termination claim. State-specific rules. Some states go further than federal law. Montana. After a probationary period, employers must show just cause for termination under the Wrongful Discharge from Employment Act. Immediate termination without cause is unlawful. California and New York. Aggressive anti-retaliation enforcement. Firing on the spot after complaints often leads to legal action. Massachusetts. Courts sometimes treat policies as implied contracts. Example: in Montana, a worker fired without explanation after 6 months can sue unless the employer shows just cause. Impact on benefits. Being fired on the spot raises questions about benefits. Here's what to know. Health insurance. Under COBRA, if your employer has 20+ employees, you may continue coverage at your own cost. Final paycheck. State laws vary, but many require immediate or prompt payment of final wages. Unemployment insurance. If you're fired without misconduct, you may qualify, but employers may contest benefits if they allege misconduct. Example: a restaurant worker is fired immediately after complaining about hours. She applies for unemployment, and the agency investigates whether misconduct occurred. Real-world cases expanded. Case 1. OSHA retaliation. A construction worker refused to use unsafe equipment. He was fired on the spot. OSHA ordered reinstatement and back pay. Case 2. Discrimination. A pregnant employee was dismissed mid-shift after announcing her pregnancy. The EEOC sued, citing the Pregnancy Discrimination Act.
Tan and Bish.
Case 3. Contract breach. A financial analyst with a contract requiring 30 days' notice was fired immediately. The court awarded damages for breach of contract. Case 4. Montana law. An office worker terminated after probation challenged the employer, who could not show just cause. The court reinstated her. Steps to take if you're fired on the spot. 1. Stay calm and document. Keep termination letters, emails, or notes. 2. Request the reason in writing. Employers may refuse, but asking helps your record. 3. Check contracts and policies. Did they promise warnings or notice? 4. Consider timing. Were you fired soon after filing a complaint or requesting leave? 5. Apply for unemployment benefits. Even spot firings may not disqualify you. 6. File complaints if needed. OSJ, EEOC, or state labor boards can investigate retaliation or discrimination. 7. Seek legal advice. Employment attorneys can identify wrongful termination claims. Example: a hotel worker fired on the spot after reporting unpaid wages files with the Department of Labor and recovers back pay. The human impact. Being fired suddenly is devastating. Workers face embarrassment, financial stress, and uncertainty. Families lose income overnight. Many feel powerless when employers use at-will rules to justify immediate firings. But knowing the law helps. Even if firing on the spot is allowed, retaliation and discrimination are not. Workers who recognize their rights can take action and sometimes reverse unfair terminations. The bigger picture. The idea that employers can always fire on the spot is only partly true. At-will employment allows it, but federal laws, state laws, contracts, and public policy exceptions put real limits on employer power. Workers may not always get advance notice, but they are not without recourse. Understanding these limits turns confusion into clarity and unfairness into action. So, What rights do you have if you're fired on the spot? Under at-will employment, your boss usually can terminate immediately without notice or warning. But there are important exceptions. Firings based on discrimination, retaliation, or violations of contracts and state laws may be unlawful. Benefits like unemployment and COBRA coverage still apply in many cases, and agencies like OSHA and the EEOC investigate retaliation. The bottom line: while being fired suddenly is often legal, it is not always the end of the story. Workers have rights, and knowing them is the first step toward protection. If this video clarified things, share it with coworkers, because understanding spot firings helps every worker face sudden termination with more confidence.